This courtroom showdown has everything millions of dollars at stake, accusations of fraud, and a house that's become the center of a legal storm. At the heart of it all is Ms. Doja Banks, who claims she has the right to stay in a $1 million property, despite a foreclosure and multiple bankruptcy filings. But the judge isn't having any of it. Over the next few minutes, you'll witness tense arguments, legal twists, and one jaw-dropping ruling that could cost someone $15,000 per month just to appeal. Who's telling the truth, and who's playing the system? Let's break it all down.
All right. Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property.
What you just heard is the plaintiff's attorney dropping a bombshell. The bankruptcy court determined that this case involves a scheme to delay, hinder, and defraud. That's serious language. When a court says something is a scheme, it's essentially accusing someone of manipulating the system to buy time or avoid obligations. Notice how the attorney mentions a 2-year bar on refiling bankruptcy. This is a legal safeguard to prevent people from endlessly filing bankruptcies. To avoid eviction or foreclosure, do you think this kind of legal loophole abuse should lead to harsher penalties?
Let me see. Notwithstanding Rule 4001A3, a bankruptcy rule,
Right.
creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
All right. Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay.
Here's where things get interesting. Ms. Banks has filed an appeal, but the key detail is that there's no current stay from the appellate court. This means that, legally, the plaintiff can move forward with eviction unless the higher court intervenes. Appeals don't automatically pause legal proceedings unless the appellant secures a stay, often by posting a bond or escrow. It's a high-stakes waiting game will the higher court step in before Ms. Banks is evicted.
Or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect.
Now, this is a big red flag, Miss Whitlow. The original homeowner hasn't appeared in court or complied with orders. The attorney is pointing out that she even ignored a federal show cause order, which is a direct instruction to explain or justify her actions. When someone skips court dates and ignores deadlines, it's usually a sign that their case is collapsing. Why do you think Ms. Whitlow is avoiding court day? Is it fear, strategy, or something else entirely?
I believe July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your Honor,
Go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired, and we came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed 2 different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was.
The attorney's narrative here is painting a clear picture of a coordinated effort to hold onto the property by any means necessary. Multiple people filing bankruptcies, sometimes from out of state, all claiming the same house. This is why the judge's patience is running thin. The mention of Ms. Banks being barred from preparing bankruptcies for others suggests she may have a history of pushing legal boundaries. This is no longer about just one eviction, it's about exposing a pattern of manipulation.
Because there is no stay in place, we would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Thank you. Ma'am?
This is a turning point. The judge directly challenges Ms. Banks' claim of rights, especially since she's not a named party in this case. By refusing to recognize the court's jurisdiction, Ms. Banks is effectively shutting herself out of the very system she's trying to appeal to. Did you notice the applause from the courtroom? That's rare in legal proceedings and shows how the judge's no-nonsense stance resonated with the spectators.
And oppose an unlawful state action. I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any
you are
rights.
not a named party. So if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow, who
you
is
need to
supposed-
go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of the.
This back and forth is both dramatic and revealing. Ms. Banks tries to recant her refusal of jurisdiction. But as the judge sharply points out, you can't just opt in and out of the court's authority when it's convenient. The judge is making it clear, without proper filings and legal standing, Ms. Banks' arguments won't hold water. It's a classic moment where emotion collides with legal reality.
So I'm going to recant that
So you are consenting to this court's jurisdiction?
at this moment.
Well, no, it doesn't work that way. You don't get to say, well, now it's okay, and then not later say no.
Okay.
You know what? Here's the problem. You've not filed anything with this court.
No.
So I don't know why, on those grounds, why I'm hearing from you.
Okay. If I may, I do have time, I do believe, to go file an answer and counterclaim. I was just led under
An
false
answer and
pretenses
counterclaim to what?
to their complaint for eviction.
You have a lease with, allegedly, with Miss Whitlow.
Correct.
Then that is who you need to pursue it against,
Okay. And
or whatever the heck you're doing.
well,
Because you don't have, there is no privity of contract to the extent there would be, or relationship as between the plaintiff in this case and you.
okay, I'm not really understanding, but
Well, let me put it a little bit more simple.
The judge now breaks down the case in plain English if the court rules in favor of eviction. Ms. Banks' only legal recourse is against Ms. Whitlow, the person she claims to have a lease with. This underscores the concept of privity of contract, meaning you can only enforce rights against someone you actually have a legal agreement with. It's a harsh reality for tenants who get caught in disputes between property owners and third parties.
there is an actual contract.
I don't know that, ma'am.
We've actually been.
I don't know
Banks.
that.
Okay, I know you don't know that 'cause it's not before you.
Correct.
I see. So basically, the notice of removal that the Whitlows did,
They are not here. I don't know. I have documents that are not, that they filed with this court that are not signed. So I don't have to accept them. She has not appeared before this court, or they have not appeared before this court. And so as far as I'm concerned, any relief they're requesting, I can, and as of right, ought deny, and it should be denied also on the merits of whatever their motion is. But I can deny it because they're not here.
okay. Again, stating to me, I want to make sure I'm clear that my issue is with the Whitlows, not with VMC.
Ma'am, I am not giving you legal advice.
No, I
You're
don't-
telling me that you have a contract. I do not know that you have a contract,
Mhm.
but if you wish to enforce that contract, that's who you're going to have the issue with. You're not going to have the issue with the plaintiff in this case because they have right to own the property.
Okay. All right, Your Honor, I will speak with the Whitlows that I have finally got an understanding of everything. And I will speak with plaintiff's attorney as well and continue to communicate with Remax, who has came by the house several times.
All right.
This is the hammer drop. The judge not only reopens the case, but sets a $15,000 per month appeal bond, far exceeding the $10,000 suggested by the plaintiff's attorney. Why so high? Because the property's value and the cost of delay are substantial. Essentially, if Ms. Banks or anyone else wants to fight this ruling, they'll need deep pockets. Do you think this $15,000 bond is fair, or is it overkill given the circumstances?
Or a rate, and I have looked at the property which is involved in this matter, and it is a significant property. I don't think the $10,000 a month quite does it based upon my calculations. So any appeal bond would be set in the amount of $15,000 per month that would need to be paid to maintain the appeal.
Thank you, Your Honor.
All right.
I will prepare that and present it to you this morning.
Thank you.
May I say something? Our lease payments was not that high. at all. I'm not sure what her mortgage payments were. That was not our amount we paid.
Then I'll tell you what. If the Whitlows wish to come and object to my order of $15,000 as an appropriate bond, they may do so. I do not believe that you have standing to object to the court's order.
And just like that, the judge shuts down the courtroom drama with a decisive ruling. The eviction is moving forward, and any appeal will cost a staggering $15,000 a month. This case is a perfect example of how the legal system balances property rights, financial interests, and attempts to exploit loopholes. What's your take? Should Ms. Banks be allowed to stay? Or is the judge right to push for eviction? Let us know in the comments. And if you found this breakdown as we did, hit that like button, share this video, and subscribe for more explosive courtroom commentary.